Hi, this is Rick Frederick, reviewing the case of Leland v. Oregon, 1952. This is a state issue presented to the Supreme Court asking whether the state of Oregon provided the minimal constitutional protections to Leland, the defendant who was charged with murder of a teenage girl who pursued an insanity defense. He was convicted based on his confession and other evidence. In Oregon law at that time, a defendant who pleaded insanity was required to prove that his insanity due to a mental disorder was beyond a reasonable doubt. So the burden was on the defendant, and the standard of proof was beyond a reasonable doubt. Oregon was the only state who required beyond a reasonable doubt standard of proof, but 20 states had the burden on the defendant to prove that they were insane. And recall that it's a long-time standard since McNaughton that the burden falls on the defendant because all men are presumed to be sane. Now, Leland argued that the scheme was unconstitutional because it required a person to prove his or her innocence, and that is not an effective argument and did not withstand Supreme Court scrutiny. As will be shown, the state of Oregon clearly required the prosecution to prove that Leland was guilty of a crime. So, did it violate the due process clause of the 14th Amendment? The Supreme Court says no. The proof of guilt was placed squarely upon the state. Only after guilt was established, did jurors consider separately the legal issue of insanity. And the court again endorsed this long-standing view of burden. 20 states have the burden. The Supreme Court found no constitutional flaw with Oregon's law. The court concluded that it was acceptable for Oregon to require defendants who plead insanity to prove that insanity beyond a reasonable doubt. Okay, so what the Supreme Court is saying, look, these are procedural rules. There's effectively no lack of protection under the Constitution. And then in the court's analysis, the court demonstrated that Oregon clearly, through the jury instructions, placed the burden of proving guilt on the prosecution. Insanity was considered only after guilt had been established. So nothing unfair there. Two justices sharply dissented with this view, however. They said that having the insanity defense be a burden of the defendant at such a high standard of proof placed defendants at too high a risk of erroneous conviction. I'm going to say, look, this argument is understandable, but it's not, there never was an element of Oregon's rule that didn't require Oregon, the prosecution, to show the requisite mental state in its prosecution at beyond a reasonable doubt. The state had to prove that the requisite mental state to commit murder was present. What Leland is saying is that then he has to rebut that once there is a finding of guilt. It's an interesting case, probably not a very important case these days, but where the standard of proof, what it should be and where it should exist, including in states where there is no insanity defense at all, is really a matter for the states, is what the Supreme Court is saying here. It's not a constitutional issue. Thank you.